Good morning, everyone. My name is Michael Kelker. I teach English at St. Charles Community College, and I'm also the organizer of Democracy Days. I'm very glad to see you here. We have a very special guest presenter today, and for that introduction, he will be introduced by our college president, Dr. Barbara Cavalier. Would you please welcome Dr. Cavalier?
All right, good morning, everyone. Welcome to St. Charles Community College's Democracy Day, which this year is focused on examining the history, health, and functioning of democracy in America and abroad. Since 2001, Democracy Days has been an honored tradition at SCC, offering students, faculty, and the community a plethora of topics and themes related to democracy. Led by faculty in our history and political science departments, this event takes an interdisciplinary approach, which also calls on the support and expertise of other disciplines, including anthropology, philosophy, literature, sociology, healthcare, and business, and many, many others. In addition to participation by our wonderful faculty members, this year we included the voices of our students, who will be or have led at least 3 sessions in Democracy Days. And we are most excited to welcome our guest presenter, Gregory Mcgaryen from Washington University School of Law. Mr. Mcgaryen is the Thomas and Karole Green Professor of Law at Washington University. He teaches and writes about U.S. constitutional law with emphasis on the freedom of expression. His first book, Managed Speech, The Roberts Court's First Amendment, was published in 2017 by Oxford University Press. His works also examines church and state firearms regulations and regulations of the political process. He has published widely in leading law journals, made numerous scholarly presentations, and taught and lectured at universities across the world. He served as a judicial clerk for Justice John Stevens of the U.S. Supreme Court and Judge Louis Oberdorfer of the U.S. District Court for the District of Columbia. He practiced law at Jenner and Block in Washington, D.C., and taught at Villanova University before joining the Washington University faculty in 2008. You know, Nelson Mandela once said, an educated, enlightened, and informed population is one of the surest ways of promoting the health of a democracy. In our own small way, St. Charles Community College's Democracy Day for the past 20 years has helped to educate, inspire, and enlighten a community of learners. My appreciation is extended to Professor Emeritus Michael Kelker for taking the lead with this event, and everyone else at our college for their contributions and for their participation. Thank you especially to the faculty members who were able to release students to participate in today's events. I'm so proud of our college and of this event, which has really become a much valued tradition at our institution. So at this time, let me hand it over to our guest speaker.
Well, thank you very much for that introduction. Thank you all for being here. It really is, it's a cliche to say when you're doing public speaking, but it really is humbling to be a part of this program. When Michael first invited me, and I thank him for that, I was grateful for the chance to talk to you all. But then when I got a look at the agenda of all the different presentations over these several days, I was just awestruck. I mean, the range of topics and the quality of speakers, presenters that you got. I don't know if you realize this, from my perspective, anyone who was interested in engaging with issues central to democracy and concerns about democracy anywhere in the country, I don't think they could be anywhere in the country this week that would be better than this right here, what you have. So I hope you are all appropriately proud and appreciative of what you have built here and what you're able to participate in. Forgive me if I'm a little awkward. It's weird, like I got new glasses. I just picked them up this morning. This jacket is new. What happened was I was at a conference and I packed up my suitcase and I looked under the bed for socks and everything, and I left my sport jacket in the closet. And I got home and I told my wife, I can't believe this, I left my sport jacket in the closet. She said, oh, thank God. Because like this is literally the first new item of dress clothing I bought in 15 years. So I'm a little bit fidgety or awkward, please bear with me. So I want to begin with a very familiar story. On a cold winter day, a large group of angry Americans illegally occupied the Capitol building. These disaffected voters were furious about the consequences of the recent election. They were mainly from the ideological extreme of their party, and they focused their passions around a highly polarizing Republican chief executive. The occupiers were challenging important aspects of the political process. Their opponents loudly condemned their actions as dangerous and outside the proper boundaries of democracy. Eventually, the occupiers withdrew from the Capitol, having failed to achieve their concrete objective, but having changed the political conversation dramatically. In my talk today, one of my goals is to explain why I think that Capitol occupation was a brave, honorable act in the best tradition of our constitutional democracy. What I just described, of course, are the events in Madison, Wisconsin back in February 2011. Of course, everything I just said also describes another Capitol occupation, the one that we are all familiar with, the insurrection at the US Capitol on January 6, 2021. For the record, I do not think that occupation was a brave, honorable act in the best tradition of our constitutional democracy. Rather, like the vast majority of Americans, I think the January 6th insurrection was toxic, despicable, and a grave threat to our constitutional democracy. But as someone who holds those polar opposite views about two seemingly similar events, I think I'm obligated to justify my position. How can the Wisconsin occupation be honorable and the Washington occupation be despicable? What's the real difference? One obvious distinction between the two events is that the Wisconsin occupiers, as I'll explain in greater detail in a couple minutes, were left-wingers opposing a right-wing government, while the Washington occupiers were right-wingers opposing an incoming left-wing or at least center-left government. But that distinction cannot properly make the difference that can justify my divergent views. As it happens, I'll just come clean right off the bat. I'm a left-winger, highly sympathetic to the substantive politics of the Wisconsin occupiers and strongly opposed to the substantive politics of the Washington occupiers. But in a pluralistic society like the United States, it's not a legitimate argument simply to praise our side while condemning the other side for doing apparently the same thing. However, I believe these two seemingly similar groups of political agitators were in fact doing very different things. Today, I want to explain why. Specifically, in contrasting these two Capitol occupations, I want to draw upon important principles from our Constitution, most importantly, the First Amendment's function in helping to enable political change. I hope to persuade you, wherever you sit on the ideological spectrum, that we should all embrace the kind of action that happened in Wisconsin in 2011, while deploring the kind of action that happened in Washington a decade later. So I assume that most of you have a fairly detailed sense of the January 6th insurrection. The House January 6th Committee has kept these events very close to the front of our minds recently. But unless you are a Wisconsin native, a political nerd, and over 30, all of which I am, you probably don't know much about the 2011 Wisconsin Capitol occupation. So I want to give you a brief rundown of what happened there. In November 2010, Republican Scott Walker was elected governor of Wisconsin. After taking office in January 2011, along with Republican majorities in both houses of the state legislature, Walker announced an aggressive legislative agenda highlighted by a bill that came to be known as Act 10. Act 10 dramatically reduced the power of public employee unions, conspicuously excluding those unions, police and firefighters, most likely to support Republican political candidates. Democrats loudly condemned Act 10 as both bad public policy and an underhanded Republican electoral power grab. Democratic state senators fled the state to prevent a quorum for passing the bill. They hid out in a hotel in Rockford, Illinois for like a week to try to avoid a vote being taken on the bill. Activists around the state took to the streets. In Madison, the state capitol, crowds of up to 100,000 people surrounded the Capitol building between mid-February and early March. On February 20th, thousands of protesters entered the Capitol grounds and building. They established an autonomous community, including sleeping areas, a medical unit, and food stations. The protesters sang, chanted, and taped protest signs to the Capitol walls. Large numbers of protesters remained in the Capitol building until a state judge ordered the last of them to leave on March 3rd. The Republican legislature, for its part, passed Act 10, and Wisconsin Democrats have never really recovered politically. So, what factors, without regard to partisan bias, distinguish this Wisconsin Capitol occupation that I just described from the January 6th insurrection that we're all familiar with? What makes one occupation, in my view at least, good for constitutional democracy and the other one bad? Let me first talk about what I see as three important non-distinctions. These are criticisms that some people have made that apply to both of these Capitol occupations. I agree with the factual premises that the two events have these factors in common, but in my view, the criticisms are wrong. These three factors that I'm going to talk about by themselves are not bad things. They therefore do not provide good reasons to condemn either the Wisconsin occupation or the Washington occupation. So I want to talk about these three non-distinctions, and then I'm going to talk about the factors that I think do meaningfully distinguish these events. All right, so the non-distinctions. First one is extremism. Some people condemn the Wisconsin occupation simply because it was led by the far left, which, by the way, is only partially accurate. Other people condemn the January 6th insurrection simply because it was led by the far right. The idea behind these criticisms is, seemingly, that centrist political actors are more responsible, credible, and valid. I strongly reject that idea. There is nothing wrong with deviating from the most widely held political views. Sometimes, often, the mainstream consensus is wrong. In fact, I think political extremism is necessary, essential for a thriving democracy. People with mainstream beliefs should have to confront challenges to their comfort zones by people with more iconoclastic views. Consider the populist and progressive movements of the turn of the last century, which inspired crucial reforms to public policy and the political process. Now, my defense of the Capitol occupiers, both groups of Capitol occupiers, extremism comes with an important caveat. Political extremism certainly can be destructive, depending on its particular content and context. The Wisconsin occupiers were extremely pro-labor. The Washington occupiers were extremely anti-regulation. That's fine. On the other hand, many of the Washington occupiers, as I'll discuss more in a couple of minutes, believed that their grievances justified violence. That's not fine. The First Amendment protects people's right to advocate violence. But the closer such advocacy comes to action, as in a mass occupation like January 6th, the more we have legitimate reason to fear that action. And I'll expand on that point shortly. A second criticism of the Wisconsin and Washington occupations that I find misplaced is that occupying Capitol buildings is improper because it's unlawful. Now, occupying Capitol buildings is indeed unlawful for an understandable reason. If people occupied Capitol buildings all the time, governments could not carry out their public duties. The Constitution gives us avenues to bring about political change through voting and through numerous forms of lawful protest. Most of the time, those lawful avenues for most people are enough. However, we have a long tradition, fortified to a significant extent by First Amendment law, of tolerating acts of civil disobedience. Acts of civil disobedience willfully violate the law in order to make a point, usually to dramatize the protester's view that lawful avenues of political change are not enough to deal with an especially urgent problem. Great recent example, the Black Lives Matter protest in the wake of the George Floyd murder. Civil disobedience, as in that example, can be disruptive and sometimes, to some people, disturbing. It upends our routine and makes aggressive demands on our attention. But all of that, I believe, contributes to a vibrant, engaged democratic discourse. Third, and finally, a third common criticism of the Wisconsin and Washington Capitol occupations that I reject is that this method of political action is too anti-institutional. This complaint holds that any aggressive challenge to the integrity of our political institutions indefensibly undermines our social order. In both the Wisconsin and Washington occupations, the occupiers' main argument was that the political process in some way had become corrupted. The Wisconsin occupiers argued that Republicans were using their election victory to improperly entrench their power by weakening their political opponents. The Washington occupiers argued that massive voter fraud had caused Trump's election loss. Some people responded to both of those arguments by saying, in effect, "You lost, get over it, our institutions work just fine." But our election laws and structures are complicated. And over our nation's history, those laws and structures have seen plenty of corruption and abuse. They often haven't worked fine. If, in fact, election structures are corrupt or infirm, that's probably the best possible justification for taking your complaints to the streets or to the Capitol building to make your case. How can you rely on elections? How can you rely on a corrupt or infirm process to correct itself? Now, again, this point comes with an important caveat. I'm not saying that all allegations of institutional abuse or corruption are equally valid. Some of those allegations turn out to have substantial grounding in empirical evidence and political theory, but others are wrong or even dishonest. If people take extraordinary measures like occupying a Capitol building to promote a charge of institutional corruption that turns out to be specious or unsupportable, then we should judge those people harshly for their mistake. I'll say more about that shortly. My point now is simply that there is nothing categorically wrong or illegitimate about crying the system is rigged. When such outcries do turn out to have merit, they perform a valuable service for the health and functioning of liberal democracy. All right, so I've just told you about these three factors: political extremism, unlawfulness, anti-institutionalism, that the Wisconsin and Washington occupations had in common, and that I think, contrary to some critics of those occupations, fully comport with our constitutional system and our constitutional values. One of the overarching reasons that I reject those criticisms is that I don't think the important considerations for judging the Wisconsin and Washington Capitol occupations are the factors that the two events have in common. Rather, I think the important considerations are the factors that distinguish the two occupations. So I now want to shift gears and discuss what I believe are the three most important distinguishing factors. In my view, consideration of these factors should inspire praise for the Wisconsin occupation and condemnation of the January 6th Washington occupation. The first of these factors is the most important by far, and it's blatantly obvious, but I think the other two also deserve emphasis and attention. The first pivotal, obvious factor that distinguishes the Wisconsin occupation from the January 6th insurrection is violence. As we all know, January 6th was a bloodbath, and that's exactly what the rioters who stormed the Capitol wanted. Those insurrectionists bludgeoned, maimed, or otherwise injured over 140 law enforcement officers. One officer suffered a fatal stroke at the scene. 4 others ended their own lives in the days and months following that traumatic day. 3 insurrectionists also died. Many of the insurrectionists carried weapons or tools for physically subduing their political opponents. They used blunt instruments to break down doors. They caused millions of dollars in damage. None of this was spontaneous or unexpected. The insurrectionists shouted each other on to violence, screaming for the blood of legislators and the vice president. Organized right-wing militias, notably the Proud Boys and Oath Keepers, meticulously schemed the storming of the Capitol. They stockpiled guns outside the Washington city limits for planned escalations of violence. The government has charged more than 900 people with serious crimes arising from the January 6th insurrection, and that number almost certainly vastly understates the number of rioters who actually participated in violent attacks on people and property. In contrast to those 7 blood-soaked hours on January 6th, the 2-week Wisconsin Capitol occupation in 2011 produced a grand total of 0 deaths, 0 injuries, and fewer than 20 arrests of protesters, mostly on minor charges. Organizers sternly discouraged violent or aggressive behavior, leading to a massive protest involving tens of thousands of people in which very few, even tense moments ever arose. Not a single protester in or around the Capitol was found to be armed. The state found no deliberate vandalism in the Capitol building, although cleanup costs were significant. Most of the protesters even used blue painter's tape to hang their signs and posters in the building because that's the easiest kind of tape to remove. In short, the Wisconsin occupiers exemplified the letter and spirit of the First Amendment. If you read the text of the First Amendment, these people peaceably assembled, they freely spoke, and they petitioned their government for redress of grievances. They demonstrated that political extremism, civil disobedience, and anti-institutionalism have no essential linkage to violence. The January 6th insurrectionists, in sharp contrast, bludgeoned their way through the First Amendment's boundaries. Could any part of our Constitution conceivably justify what they did? Only one constitutional argument is possible, and it's a really bad one. The Second Amendment right to keep and bear arms, viewed in its historical context, appears to have been intended to authorize the people to violently overthrow a tyrannical federal government. Many of the most avid gun rights partisans continue to embrace this insurrectionist reading of the Second Amendment, and the January 6 rioters seem to have taken it quite literally. Unfortunately for them, that insurrectionist reading of the Second Amendment, while historically well-grounded, is also completely insane in the conditions of our contemporary society. Even the generation that ratified the Second Amendment quickly came to realize that a nation founded on political pluralism could almost certainly never reach a strong enough consensus about governmental tyranny to justify constitutional cover for insurrection. That's exactly why the Second Amendment sank into the murk of history until the current Supreme Court saw fit to exhume it and reinvent it as an anachronistic vehicle for protecting personal self-defense. But that's another conversation. A second factor, important factor, that distinguishes the 2011 Wisconsin and 2021 Washington Capitol occupations is authoritarianism. The Wisconsin occupation was a legitimately grassroots movement. Labor unions, student groups, and some Democratic political leaders featured prominently in the movement, especially as it gained momentum, but it had no formal leadership, and no mastermind appears to have strategized the Capitol occupation itself. No person or organization even emerged as the face of the movement, either while it was happening or later. In short, no identifiable, powerful person or group bore any substantial responsibility for the Wisconsin Capitol occupation. There's a word for this kind of organic, collective political energy, a word that I think has recently gotten an overly simplistic bad rap, and that word is populism. Populist protest can play a highly valuable role in our political system. Our Constitution's animating idea is that we, the people, are sovereign. However, the Constitution limits opportunities for the people en masse to cause political change. The people can't make laws, Congress does. The people don't elect the president, the states do, through the Electoral College. Originally, the people didn't even elect US senators, the state legislatures did. The Constitution therefore makes popular sovereignty central, but also contingent. The First Amendment complements the Constitution's political structure by giving the people a voice without giving them a formal lever of power. Popular movements can't govern, but they can assemble, express themselves, and seek to influence governance and to persuade the broader public. They don't get formal authority, but they get the chance to directly and indirectly influence those with authority. That's exactly how the Wisconsin Capitol occupation operated. The January 6th insurrection, in contrast, was incited by the single most powerful person on earth, with the enthusiastic participation of other high government officials. This was an attempted coup from within the government itself. To be sure, January 6th involved a certain kind of mass movement, but that movement, regimented by the Proud Boys and the Oath Keepers, styled itself as the president's personal shock troops. January 6th was the furthest thing imaginable from the popular sovereignty of the Wisconsin Capitol occupation. Where the Constitution takes pains to separate popular sovereignty from coercive political power, January 6th collapsed that separation. Trump harnessed what I would call an artificial mockery of populism to perpetuate his own regime. I use the word authoritarianism, but there's another word for Trump's warped, state-affirming vision of populism, and that word is fascism. Indeed, Trumpism embodies an essentially fascist cult of personality. The founders of our republic recognized the dire hazards of putting any person, any man, above the law. But the entire point of January 6th was to put Trump above the law. And by the way, just a footnote, I first gave a version of this talk back in mid-August, so whatever you think of what I'm saying, don't accuse me of plagiarizing the president for calling Trumpism fascism. I came up with that one on my own, as did a few other people, rather organically. Okay, the final factor that I think distinguishes January 6th from the Wisconsin occupation is bigotry, especially but not exclusively racism. The January 6th insurrection sent an unmistakable message that some people are inherently more valuable, more worthy, more American than others. To be sure, our Constitution in its original form explicitly embraced that idea. It treated African Americans, women, and Native Americans as less than human, and it countenanced the racist exclusion of disfavored immigrant groups. We haven't come close to fixing those problems politically, but at least belated amendments and court rulings have made them no longer matters of constitutional mandate. I've said that my reasons for praising the Wisconsin occupation and condemning the January 6th insurrection, in order to be fair reasons, need to be free of partisan bias. But they don't need to be free of any and all ideological content, what political analysis ever is. The January 6th mob was almost entirely white and overwhelmingly male. Some rioters carried Confederate flags, wore white supremacist insignia, and shouted bigoted slogans. They alleged that massive voter fraud had occurred in big cities. That claim might be fair enough to raise, except that 2 months of incessant probing had turned up no evidence to support the claim, beyond the inescapable fact that all the alleged centers of this so-called massive voter fraud, the urban cores of Atlanta, Detroit, Milwaukee, and Philadelphia, are overwhelmingly African American. I hope and trust that reasonable people of the left, right, and center uniformly reject the miserably persistent lie that black people lie and cheat just because they're black. The Wisconsin Capitol occupiers were a multifariously diverse lot, graded on a Wisconsin curve, who didn't negate anyone's humanity. They were certainly angry, and I'm sure you could fill volumes with mean things that those occupiers said about Republicans and conservatives. But the First Amendment centrally protects the right to throw elbows, even sharp ones, at our political opponents, because politics are just beliefs, and beliefs can change. That changeability of political beliefs is a core premise of any liberal democracy. It's why free speech matters so much for the vitality of our political system. If you tell me, or even shout at me, that my policy preferences are wrong, you're advancing our Constitution's values. But if I tell you that I matter more than you because of your race, or your sex, or your sexual orientation, or your gender identity, or your religion, or where you were born, then I desecrate the best version of our Constitution's ideals. I hope I have credibly justified my belief that the 2011 Wisconsin Capitol occupation was constructive and harmonious with our constitutional principles, while the superficially similar 2021 U.S. Capitol insurrection was destructive and anathema to those principles. I think both sides of that equation are equally important. Liberal democracy needs dynamic, sometimes disruptive political agitation in order to thrive and grow. But liberal democracy cannot hope to survive triumphs of violence, authoritarianism, and bigotry. Sometimes, at a glance, it may be hard to distinguish between constructive and destructive political agitation. At those times, we need to step up, look more closely, and deploy our best critical intellects. Nothing less than that will allow liberal democracy to persist. Thank you all very much for listening to that spiel. And as you heard at the beginning, I just want to tell you a couple things about what I do. I do First Amendment law centrally, mostly free speech stuff, but some freedom of religion issues as well. I've also written a lot about the Second Amendment and gun regulation. I gave you a little flavor of my views on that topic in the course of my remarks. And I teach general courses in constitutional law and legislation. I mention all of this because I'm happy to answer questions about any of what I just said. I'm also happy to answer questions about any of the stuff that I do, or frankly, I'll take a shot at anything. I mean, you know, if you're just troubled by some problem in the state of the world, I won't completely fake it to make it, but I'll give it my best shot. So I'm happy to hear any and all questions.
I've got a microphone, and I invite you just to stand up and speak loudly, but let's hear to the side before you, Paul.
So how do you feel about Roe v. Wade? How do you feel about Roe v. Wade?
Everything. remarkable concept.
It's a little edgy, so you can either this mic, whatever.
You need that one, so I'll do this. Sorry about that. But I think, there's an essential normative argument that you can't get away from underneath the issues involving Roe versus Wade. I think we have a tendency, and this actually, I was watching the last fantastic panel on book bans. I was thinking something vaguely similar to this, and if you want to hear my spiel on that, you can ask me about it. But, it's not that? Okay. Okay, is this one happening? Okay. That sounds like if reasonably. So, there's like a fundamental conflict of values, and the court decided to take a side of that conflict of values and render it as a have like meaningful sort of dry, neutral arguments about whether versus Wade is or not valid law. It comes down to your conception of human person and what constitutes human value. And trying to be strictly fair to both sides, there's the side that says women's capacity to control their bodies and to have access to health services is essential to human value, and there's the side that says protecting fertilized eggs from the time of implantation is essential to human value. And I come down on the first side, the court came down on the first side, the court has now come down on the second side, essentially, and I think the court has done something very destructive and unwise. But I guess what I'm trying to say is I can't so much criticize them for overruling the decision. The Supreme Court makes law. That's what it does. I just think the Supreme Court made it really bad when it overruled Roe. All right, we're gonna do this. I said, gentlemen asked if I had slides. I don't have slides on low tech. So I guess if I'm low tech, I gotta encourage my convictions to just sit up here and talk about it. That is what I will do.
Sir, people are having these discussions about abortion. Do you often find that they end up kind of talking past each other? Because I find when the person on the right talks about abortion, right, they're talking about the fundamental value of the line of conception, while it seems the left are just talking about maybe women's rights, and they just find, and I just kind of see like both of them are talking past each other instead of talking like the two.
Yeah, so the question is, are abortion debates, abortion debates generally sort of amount to people talking past each other? And I think they do. I mean, I think that's a fair description. The thing that I always find kind of ironic is that Roe versus Wade, I believe in the minds of the justices who signed on to that decision, was a sincere effort to try to thread that needle to some extent. Roe versus Wade is not an absolutist decision. The trimester framework of Roe acknowledged that the Constitution should not stand in the way of state governments that wanted at later stages in pregnancy to impose restrictions on abortion. So Roe is not an absolutist, women have rights in the interest of the protecting fetal life is invalid. The problem, I mean, and I think, again, here, I've told you what my own biases are and what my own views are. I think that continues to be the predominant position of most people who say in public opinion polls that they favor access to abortion rights. They differ, the people who answer yes to that question differ about a lot of things, but none of them would say that a late-term abortion for anything other than a very pressing medical reason should be justified. And that position, that is an important concession to the other side of the debate. The most prominent, dominant voices on the other side of the debate don't want concessions. They want complete restriction on abortion from the moment of implantation. So it's possible to try to thread the needle, but nobody's really been, there has not been a critical mass of people who've been happy, who've been able to settle on both sides of the divide with those efforts to thread the needle, because I think that's what Roe was trying to do.
Good question, thank you. Did you have a question, Paul? Yeah. And I would like to recommend Professor Magarian's book. It's titled Managed Speech, The Roberts Court's First Amendment. It is in our library. Actually, I have it right now, but it is part of our SCC library collection, and I've just been able to start it. It's highly readable. In other words, it's not so technical in legalese that ordinary mortals like myself would be able to understand. So I do recommend the book.
I really appreciate both the recommendation, and I really appreciate your saying that it's readable, because I tried really hard. I will also say, yeah, I would love it if you read the book. Definitely don't buy it, because like they priced it at, I like to say they priced it direct to landfill at like, you know, $75 a copy. So I'm glad the library has it. You know, if you want to tell your public library to get it because you can't wait for Michael to give up his copy, I would be humbly grateful. But for God's sake, don't spend your own money on it.
Yeah, I teach politics here, and one of my assignments last week, we did civil liberties, was actually talking about the January 6th riot and asking my students if they thought the Brandenburg test applied, or where they would fall on that. So I'd love to hear your thoughts, and you can give my students the correct answer now that the assignment's done and turned in. What they thought, what you think of whether the Brandenburg test applies to this.
It's a great question. It's a
Trump,
hard
obviously.
question. So for those folks who aren't in your class, I want to just give you a brief primer on the Brandenburg test that you just referred to. So maybe the primal question in First Amendment law is, what do we do when people advocate violence, and in particular when people advocate violence against the public or against the government? And in the earliest Supreme Court First Amendment decisions, which only started happening at the end of World War II, the Supreme Court said it's okay for the government to punish or restrict people who advocate the violent overthrow of the government. And at the height of that point of view, the Supreme Court decided a case in the early 1950s that upheld the federal government's prosecution of the leaders of the U.S. Communist Party. The prosecution was basically just based on the fact that those people were the leaders of the U.S. Communist Party, that they were advocating communist doctrine, which included advocacy of the violent overthrow of the government under certain circumstances. And the Supreme Court said, yeah, the government can punish those guys for that, that's fine. All right. That's during the McCarthy era. About 18 years later, when those particular passions at least had cooled a bit, the court decides a case called Brandenburg versus Ohio, which interestingly arises out of a Ku Klux Klan rally. And in Brandenburg, the court changed the law about advocacy of violence. And actually, the court in Brandenburg actually implemented some ideas that Supreme Court Justices Louis Brandeis and Oliver Wendell Holmes had been advocating 50 years earlier. But essentially, the Brandenburg test makes it very, very hard for the government to prosecute anyone for advocacy of violence. In fact, to put the matter simply, you can't prosecute advocacy. You can only prosecute what's called incitement. And incitement under Brandenburg requires that the speaker knows or should know that the speaker's words are very likely to bring about serious violent action and harm with no time lapse immediately. Now, the question is about January 6th, and I think inevitably, the heart of the question is about Trump's speech on January 6th. I will tell you that for years before January 6, 2021, when I taught Brandenburg, I would say fairly casually, in order to make out a prosecution under Brandenburg, you would have to have a charismatic speaker talking to a riled up mob, some of whom were armed, and saying, go attack that government building right there. So, if I was right about that, I think there is a very good argument that Trump's speech is one of the few phenomena in any of our memories that would, in fact, be subject to prosecution under the Brandenburg test, leaving aside questions of whether the president has immunity from prosecution because he's president. Even at that, I don't think it's an easy question. So Trump's defense, if he were ever prosecuted for incitement, would be, look, I didn't say go kill people, go hurt people, go beat down the doors of the Capitol. I just said, let's fight, and you know, it's an election, and I was saying, let's fight and if I were prosecuting, I'd feel decent but not great about my chances of overcoming that argument. So for those of you who answered the question either way, you had decent arguments to go either way. But I'm a lawyer, we always say that.
I just want to let this guy that's got his hand raised, that we'll get you in a second. Yes. Hi, I am a history teacher here on campus. Thank you for coming to talk to us today. I wondered if you could address some of us, one of the things I've noticed is my students aren't really aware of why people were concerned about the insurrection. Like, it seems like, you know, for us who were like terrified when we watched it, like, I mean, I was watching it and I was like in tears, like at my doctor's office, because I couldn't believe it was happening. Can you explain like why people who watched that insurrection would then have a fear for whether democracy would continue? Like, could you just like lay it on us, like why that was a significant event and why we should be concerned about it?
Yeah. And I guess the first thing I want to say is I don't get that at all, except I kind of get it in that one just feature of human experience is that whatever you sort of see when you're growing up, you kind of internalize as like, okay, that's kind of how the world works. And so I want to be clear, I'm not saying, oh, you kids, you don't understand anything. I'm saying you kids, like all other people your age since time immemorial, and all other people, frankly, of any age since time immemorial, understand what you observe as normal. And so if it feels like, okay, why are people making such a big deal out of this? I get that on that level. But I can sort of pivot from that to say the normalization of violence is exactly what's really scary. I think the scariest implication of January 6th. To try to put it in some perspective, we've never seen anything like that in anyone's living memory. We've seen violent protests of different kinds. We've seen abuses by government, violence. I mean, this is not the first time bad, violent stuff ever happened. But a violent attack and a very effective, largely successful violent attack. I mean, these folks came within an eyelash of killing members of Congress, or at least, you know, kidnapping members of Congress. Nothing like that has ever happened. I was trying to think about this when I was watching on January 6th. I remembered back the 2000 presidential election, the George W. Bush, Al Gore presidential election that was such a close election and came down to a few votes in Florida. There was a scene where like the Republicans sort of sent a bunch of people to descend on the place where, one of the places in Florida, or a couple of the places where some of the votes were being counted. And I remember at the time we thought, oh my God, that's unbelievable. I mean, you sent a mob to potentially interfere with the votes being counted. Okay, so compared to January 6th, that was like a lawn party. That was nothing. And from my lived and observed experience, for whatever it's worth to anybody, seeing that happen in 2000 and then seeing something happen 21 years later that makes that, what in 2000 seemed like a huge kind of menacing thing, feel like an afterthought, that's terrifying. Like the idea, and then you get the follow-up where a lot of people, a large segment of the public says, what happened on January 6th was no problem, or it was a good thing. You know, the idea, and this is an idea that's kind of come back into stronger currency as one aspect of the gun rights debate and advocacy. The idea that violence against the government is justified. I mean, look, I'm not saying there aren't complications here. If a cop attacks you, you know, without reason, and you feel a need to defend yourself, I'm not going to be the one to tell you you've got no reason to defend yourself. I'm not saying the government doesn't engage in unjustified violence. But I'm saying if anybody who thinks that the way, a legitimate, viable way of challenging what they see as abuses of government power is to go and try to hurt people, that's it. That's the ballgame. If that idea prevails, then we're done. And our government just becomes a system of absolutely unadulterated force. Whoever is strongest wins. And look, our government is, our system, our society is already too much like that. Again, I'm not saying we live in paradise, but I'm saying even given all the stuff that's pathological about our society, for something like January 6th to happen, that just takes pathology to a whole different zip code. So that is my humble effort to persuade you that you should be terrified about what happened on January 6th.
Thank you. So I was just gonna, you know what? I'll just. Sure. Thank you very much. So I was just gonna ask about the previous topic, right? You brought the SM. I'm not familiar with the term.
The Brandenburg, the incitement stuff?
Yeah, exactly. So you said that he would have that saying like Trump, okay, during his speech said those things, right? But nothing happened.
Right.
He'd still get the same consequence, essentially determine the same consequences under that text.
It's a really interesting question. What would happen hypothetically if Trump said things that could clearly make him liable for incitement if violence followed from what he said, but in this hypothetical we're imagining the violence didn't actually happen. Trump just made this, lunatic incitement to violence speech, and the audience just sort of sat there and was like, yeah, okay, and then went home. And it sort of depends ultimately on the nature of the state law. It would be constitutionally permissible to punish someone in those circumstances. Like under the Brandenburg test, my sense of it is it would be constitutionally permissible. That variation, like from the standpoint of, law professors who have to think about, supposedly have to try to think about every angle of this, that's actually a really important question. As a practical matter, it isn't likely to come up because first of all, there's a tiny range of speech that could even conceivably be prosecuted as incitement without running into the First Amendment. And it's almost, nothing's ever going to happen in the scenario we're talking about where somebody makes the inciting speech, but the incitement doesn't take. So like normal people don't think about that very often. People like me, find it fascinating. So it would be constitutionally permissible. It almost never happens just because the thing that tends to trigger law enforcement attention, which almost inevitably comes after the fact because incitement is something that happens in the moment. What triggers law enforcement attention is the violence that happens and then tracing that back to the source.
Very good question. Who else? Yes.
So I'm from a very rural, red part of the state. And I know the people around me who live around me and everything would respond very differently to this speech that you just gave, and would become very irritated, agitated, and then nothing would come through. In your opinion, what would be the best way to kind of reach out to those kinds of people and try and help them understand this perspective? Because that's something that I always have trouble with because these topics do inevitably come up in conversation.
That's a great question, and my answer is going to be inadequate, partially because, candidly, I don't know those folks, really. Interestingly, half of my family background, my mom's family, are from western, rural, super small town Ohio. So I know that, I feel like I understand or have some basis in, I'm not just a big city kid, but as it happens, my rural small town relatives are all like New Deal Democrats and never changed. So, they're like the only Democrats in their town. So this is probably tells a lot about why I turned out the way I did, for better or worse. I get the sense, and you will know much more about these premises than I do, that a big thing that divides people is where they're getting their information. And Fox News is the sort of big avatar of this. But undeniably, across the ideological spectrum, there has been a sorting of information sources. And the really, really sad irony of that is that, as I think this came up on the library panel, like technology has driven that separation. But the technology that has driven that separation holds within it the greatest promise for overcoming that separation that we have ever had as a species. Like, to put it simply, if we use the internet well, all of us, we would be living in a small d democratic paradise, because we would have limitless access to other people's ideas. We would be able to learn across boundaries. People who don't spend time in small towns would be able to learn what people in small towns are thinking. People in small towns who don't spend time in big cities would be able to learn what people in big cities are thinking. And so we've got this paradise within our reach, and instead it's turned to complete ash. And I don't know what to do about that, but I feel like that's the starting point. Just talking not about the substantive politics, but about how, okay, when you say, and again, I can only imagine you've had these conversations, and so I'm not sitting up here saying I know how to have these conversations, or let alone that it's any kind of easy. But when you say that, you think the election was stolen, where are you getting that information? And, you know, what if we looked at some different sources of information that said different things about that? I'm not telling you what to believe. I'm just telling you, you know, try it. I feel like you, again, I'm an educator, so I've got this weird, persistent belief in rationalism that might be stupid, but like, you know, trying to get down to the core of what most people think of as common sense. Like, how do you learn? You know, if somebody told you, oh, you can stand out in the middle of the street, you won't get run over by a truck, you know, you wouldn't take their word for it. And you wouldn't take their word for it if they were your best friend. You would be like, I'm skeptical. I'd like to know more. I'd like to maybe look down the street and see if a truck is coming. And I think that's something that most people, regardless of ideology, you know, there are basic ways in which we sort of think about common sense and information. And if you can sort of have that conversation, don't say like, stop watching Fox News, watch this other thing. Instead be like, look, just try this other thing a little occasionally after you watch Fox News, you know, look at this other source of information and just, like, this is a tangent, but it's an important tangent. One of the big pieces of rhetoric in like the anti-vax movement has been the I do my own research thing. And people have come, you know, people like, you know, urban liberals have come to mock that, like, oh yeah, you do your own research. And the thing that's really sad about that is like, that's what we want people to do in a form. It would be good for democracy, it would be good for our society if people actually did make an effort to learn stuff. But unfortunately, what too many people mean when they say I did my own research is I found a source of information that validates the bias that I had before. So I would love for people to actually do their own research, to actually avail themselves of the different sources of information they have and use the good functioning minds that everybody has to come to a rational conclusion. And that's not much, but it's the best I can do. It's a great question. Just one other thing about that. People, the other thing I think, like again, I've got my family, my background, I got people from all kinds of different, you know, settings in American life. And I think the one thing that really bugs me about people in my ideological camp is when they belittle people who live in different circumstances than they do. They just say, oh, these small town, whatever. And like, don't do that. That's stupid and it's wrong. Like, if you start out, and this doesn't cost anybody anything, anybody who just like should start out by thinking, okay, I'm gonna be empathetic. I might, you know, I'm not gonna pretend that I have to meet you halfway on the election was stolen, but I'm gonna be empathetic and respect who you are and where you're from, and I'm just gonna disagree with what you're saying. And if we, people like me, and ultimately everybody starts there, then we've got some hope of having a reasoned debate, so.
Thank you. I've got a question. Could you speak to the nature of the court cases following the November 2020 presidential election? Apparently 6 court cases were filed, and I think the Trump camp won one of them, and I don't know the nature of that win. But in court, it was a clear-cut case, and one of the terrible shocks for me about January 6th was that it had been litigated, the election had been litigated and recounted, and what wasn't there to accept out of 6 court cases? Could you speak about those?
Yeah, I mean, at one level, there's not much to say beyond what you already said. And I will say this, after the next presidential election, whoever loses is going to bring a bunch of court challenges. And, you know, let's say it's the Democrats that lose, Biden or whoever replaces Biden on the ticket. And the Democrats are going to bring court challenges, and the Republicans are going to say, oh, you hypocrites. You complained so much when we said the election was stolen, and now you're challenging the election results. And the thing that I think we need to acknowledge to avoid that fallacy is there's nothing wrong with the litigation. Some of the arguments, I would say, as a lawyer, some of the arguments were incredibly stupid. But you know, you can bring stupid lawsuits, and courts can say those are stupid lawsuits, and many courts came very close to saying just that. So that's exactly, you're right, like that's exactly what you want to happen. You're like, okay guys, you're worked up about thinking you lost the election unfairly, by all means, use the justice system. Use the legal means at your disposal to bring your claims, to present your evidence, and you know what? If it gets you anywhere, you're going to get some momentum because people are going to believe you. Because these, hopefully neutral arbiters in the judicial process will have said, yeah, you're right, you got hosed by the election system. And as you said, emphatically the other thing happened, where the court said there is nothing here, there is no fraud. I can't remember what the one win was, but it was trivial. And it wasn't anything that would have swung any significant number of votes in any of the close states. So yeah, in a kind of functioning political culture, that would have been the thing that tamped down the extreme response. And I think the fact that it didn't happen that way, for some people it did. I mean, I think there are a lot of Republicans out there who are like, okay, I don't trust the Democrats, but the court, 50 courts say nothing bad happened, all right, I'm gonna go about my business. I don't think those people get enough attention. They're thinking reasonably about what they see. But for enough people, and for the January 6th people certainly, it was just like, anything that contradicts my assumption or bias about what happened is wrong by definition. And Trump set the tone by essentially saying, it is not possible, before the election, it is not possible for me to lose this election fairly. That cannot happen. And as soon as Trump said that, the die was sort of cast in terms of how at least an extreme segment of his base was going to react. So yeah, that should have been the end of the story if the story hadn't ended prior to it, but we're at a point where nothing is enough for a certain segment of the populace.
Thank you. Yes, up here in front. You want to just get up, stand up, and
yeah, no,
and
I
shout?
can repeat your.
Yeah.
If you want it, but you don't. I can hear you, and then I'll repeat what you say. All right, this is I'll try to restate what you asked briefly and tell me if I miss anything crucial. But this is something that we could literally talk about for hours. It's really, really complicated. So it's a question about separation of church and state. And the basic question, I think, is, okay, fine, we've got what people who think about this stuff a lot would call a rule of neutrality between government and religion. Government can't interfere with religion. Religion is barred in various ways from interfering with government. But doesn't it go too far to use the Constitution to impose rules that, for example, take prayer and the Bible out of schools and sort of try to remove the influence of religion from public life? And isn't a consequence of that removal to sort of replace one religion, usually Christianity, with a different, effectively what is a different religion, a religion of secular humanism that has the same kinds of features and attributes in terms of a comprehensive belief system that an actual religion has? Is that pretty good? Okay. So, first of all, just you'd probably be glad to know that I think the current Supreme Court is of a similar mind to where it sounds like you are from your question. There was a big decision you might have read about at the end of this last term in June about a high school football coach who had a practice of, right after the game, he'd go to the 50-yard line and kneel and say a prayer, and he would encourage players from his team and the other team to join him, and on many occasions, many of them did. And the school district essentially said, you're injecting religion into your duties as a public school teacher. And he said, no, I'm not. And the Supreme Court agreed with him and said, yeah, the Constitution doesn't bar that. So the court is, I think, moving away from some of the things that you're criticizing in the 60s. I'll again, just to make sure that I'm not holding anything back, I tend to take a different view, but I'll try to just take an analytic approach to what you're saying. On the library panel, one of the interesting things, the gentleman on the panel at one point said, remember, the library is the government. And he's right, like in an important sense and in a technical sense, the library is the government. At the same time, it seems kind of counterintuitive, right? You don't go to the library and think like the same thing that you think if you're walking into the Capitol building or City Hall. You don't think I'm going to see the government. You think I'm going more like what I do when I go to a store or something, except this store is free, and how awesome is that? Schools are in a little bit of a similar position in that quirky space where schools are government, they are public institutions, but they are also civic institutions. And so to try to frame the analysis a little bit in a way that I think aligns with what you're saying, or at least makes sense in terms of what you're asking, people who want to take prayer out of schools and to be very, rigorous about that are really viewing schools primarily as the government. They're really thinking, okay, if prayer is in schools, then the government is in some sense promoting or countenancing the practice of a particular religion. I think the people who want more religion in schools, or want at least fewer barriers to religion in schools, are thinking of schools as civic institutions. Just as lived spaces where, hey, I'm a Christian, I'm a devout Christian, I want my kids to live as devout Christians, and I don't want them to be disconnected from that central part of their identity when they walk into a school. So I think analytically, both of those premises have some value, like schools are the government and schools are civic spaces. So there's a disconnect there that's pretty hard to resolve. The other part of your question about the sort of secular religion is fascinating, and it has lots of different implications. So the First Amendment talks about the free exercise of religion getting constitutional protection, and no state shall establish a religion, and that's been extended to the federal government. So a lot turns on what you mean by religion. And at various times, the Supreme Court has been pretty rigorous in what it means, in what it takes to count as religion. Like, should I be able to say, hey, I invented a religion yesterday, and I fully adhere to the beliefs of that religion, and that religion says I don't have to pay taxes, so you're oppressing me if I pay taxes? Like, that sounds pretty sketchy. And there's stuff in law about how you can't, you got to pay your taxes anyway. But, so, like, your characterization of the kind of, I'm going to paraphrase imperfectly here, but sort of anti-religiosity in public as a form of secular religion, I think that makes a good deal of sense, but I think the implications of that are very far-reaching. I think if we treat secularism as a religion, as a comprehensive belief system, then that means that it can't be established, and also that its practice must be protected. I think, to put it bluntly, I think a lot of people who look favorably on various kinds of legal and judicial protections for religion, usually for Christianity, would not like very much the implications of extending those same protections to secularity. Although, as you point out, it would be a basis for saying, okay, you can't just establish secularism in schools. And part of what, this is a theme that just keeps coming up in my head again, that goes back to the library panel. Like, we want, in a, broadly using this term, a liberal democracy, we want to achieve neutrality in a lot of different ways. And the problem is that there is no such thing as neutrality. There is no such thing as a path of least resistance when it comes to navigating the space between people with theistic religious beliefs and people who reject theistic religion. Like, there is no neutrality. Everybody believes something. You're right about that. and the law tries to take a posture of neutrality, and ultimately I think that doesn't hold up logically, and that creates a lot of problems. So, just some musings for whatever they're worth.
I think we have time for just one more question, and I'm going to ask it, if you don't mind. You clerked for a Supreme Court justice. Could you explain what that job entails and what your experience was?
Yeah, so that was the best. That was the absolute best. So if any of you end up going to law school, I strongly encourage you, after you graduate from law school, to clerk for a judge. The judges at every level of the judiciary, state, federal, local, trial courts, appellate courts, all hire usually new law graduates to be law clerks. The positions last for a year or 2 years, so it's a quickie climb of the learning curve, and you're basically there as hired labor. Like the judge or justice has to write opinions and has to review a lot of briefs, and you're sort of their helpers. So typically, like on the Supreme Court, Justice Stevens had 4 clerks, and so we would split up that work. We would look at all the petitions that people filed to try to get the Supreme Court to hear their cases, and that was like, at that time, like 5,000 petitions a year. Now it's much more than that. We would help the justice prepare for the oral arguments when the lawyers come to court and make their arguments to the court. Before they do that, they file briefs which summarize and state their arguments. So the justice would read the briefs, we would read the briefs, and then we'd sit down and have kind of a round table and just sort of talk about what are the big legal issues, what are the uncertainties, help get him thinking about what he might want to ask the lawyers in open court. And then after the arguments, when the justices voted on how the case was going to come out, if Justice Stevens had an opinion to write, either a majority opinion or a dissenting opinion, we would assist in the drafting of that opinion. He would say, okay, here's how I want this section to come out, write me up a draft that, states that reasoning, and then he would work it over. It was amazing. And in general, like anything in life, there are sometimes bad experiences because judges have a lot of power, but I worked with 2 judges, a federal district judge and then Justice Stevens, and were amazing experiences. These 2 guys who had been, as it happens, on the bench for a long time, they knew their jobs, they knew the law inside and out, and it was just like being an apprentice in the shop of a grandmaster of some kind of craft. I learned a ton. It's terrifying to look back on it and to think how little I knew, and how utterly useless I must have been given how little I knew. But I think that's part of the point. Like, if you're hiring new law school graduates, they haven't been out in the world, they haven't done the work yet, but they are young and smart and willing to sacrifice a lot of sleep, and so that the justice doesn't have to. So I could go on at great length about that, but that's the basics. It was a fantastic job that experience I was very, very lucky to have.
Thank you for that. Let's show our appreciation.
Thanks, everybody. Thanks for all the questions. Great stuff, and it was really fun to get to talk to you.
Thanks for coming, everyone. We have a 1 o'clock session, and we have voter registration taking place right outside these doors. If you're not registered, you can do it in about 2 minutes.